Welcome, everyone. We're going to call this meeting to order now. It is 6:30 p.m. I'm sorry, it is 6:39 p.m. on February 13, 2023, and this is a public meeting of the City of Portland Police Accountability Commission. My name is Victoria Lara, and I will be your facilitator, your main facilitator today with Dr. Moses, our support facilitator here. Thank you. The city offers ASL interpretation when it's going to be provided later by Andrea and Amanda. Please pin their video feed to see their interpretation throughout the meeting. The closed captioning is turned on in Zoom as another means of assistance. But please note that this is an automatic captioning services and is not always accurate. This city support access to meetings of the Police Accountability Commission and can provide other language support as well. Please email in advance of future public meetings, either as a response to a public meeting notice or directly to policeaccountability@portlandoregon.gov to ask for other access assistance, including interpretation into other languages. This meeting is a public meeting subject to the City of Portland Administrative Code and Oregon State Law and is being recorded. For the meeting, the chat function is enabled for commission members to communicate with each other. Members of the public will be able to ask questions using Zoom's Q&A feature as the commissioners are presenting and/or discussing things. If attendees have questions, please feel free to submit them through the Q&A. We hope to use this feature to help guide our conversation during the meeting and future meeting agenda topics. We'd like to be clear that not all questions will be answered during the meeting, but if answered, both the question and answer will be visible to you and will become part of the meeting record. To access this feature, just click on the Q&A icon in the middle of your screen. Now I will pass it to the co-chairs for the land acknowledgement.
Thank you, Victoria. We are currently using the city's land acknowledgement, which I will read right now. Also, Christian, co-chair, for the record. We acknowledge that the rivers, lakes, streams, and lands of the lower Willamette River rest upon the occupied territories of the Multnomah, Wasco, Cowlitz, Cathlamet, Clackamas, Chinook, Tualatin, Kalapuya, Molalla, and many other tribes. We recognize the many villages, traditions, cultures, and relationships that existed along the river since time immemorial. We recognize these tribes stewarded these lands and rivers since time immemorial for future generations. We recognize and undertake responsibility for the destruction of the river and land of traditional food resources, sacred places, and multifaceted ways of life. We acknowledge the economic and social values that enabled the harm to the river, including systemic racism, classism, and other systems of oppression that perpetuated harm against Black, Indigenous, and immigrant communities along the river. With this acknowledgement, we commit to honoring and learning from the past and working towards a more equitable and sustainable future for the lower Willamette River. We commit to seeking solutions that acknowledge the inequities of past socioeconomic policies and the harm done to people and our relationship to these lands and waters. And I'll pass it back to the facilitators for the community agreements.
Thank you very much, Co-Chair Christian. Now we're gonna review the community agreements. And there is a part on one side, there's a little cut. Yeah, you can move it to the right, I will say a little bit. Yeah, perfect. Thank you very much. We're gonna review the community agreements. Each person, please read it and reflect themselves in silence. There is 3 pages, and then I can ask the question. Thank you. Next page, please. Next page, please. If you notice that a conversation is coming close to violation a community agreement, please call your fellow commission members and gently and with compassion. If you are called in, please take a moment to consider how you can best participate in the space while still respecting the community agreements and making a space for everyone. Do we all commit to following the community agreements for today's meeting and to gently calling in our college and collaborators if needed? And you can show me your hand. Yeah. Thank you. Now I will pass it to the co-chairs to discuss the timeline.
This meeting is a part of the Police Accountability Commission's powers and duties phase of work, which focuses on the functions of the new system. Future phases of work will develop the form of the new system, as well as how it relates to the rest of the city government and the transition plan from our current system to the new one. The commission will present all proposed changes to the city council in 2023 for their consideration and approval, and has requested by consensus that the city council allow the commission to work through October 29th, 2023, as envisioned in the settlement agreement. Slide 8. Okay. This slide shows the outcome documents for the powers and duties phase based on the agenda and scope approved by the commission. The commission has completed its work on the areas of agreement on access to information and the areas of agreement on structural oversight. Today, it will begin discussion of the areas of agreement on officer accountability referred to the full commission last Thursday. This slide is the current project plan for the powers and duties phase of the Police Accountability Commission's work. It will be updated as needed throughout this phase of work. This slide is for members of the public to be able to understand how the commission gets from now through the end of the phase, which focuses on identifying areas of agreement among commission members as to the functions of the new system. Today's meeting is part of the blue box with the red border near the upper right corner of the screen. Following today, here are the upcoming meetings of the PAC. Specifically, we'd like to highlight there's no meeting on Monday, February 20th, as the city observes President's Day, and structure and details phase will begin with subcommittee meetings the week of February 27th. And today's meeting agenda includes working through the draft areas of agreement on officer accountability, flagging items for further discussion, resolving items, and if possible, approving the final document as the PAC areas of agreement on officer accountability. All document approval processes include a review of the PAC values and goals and hearing public comment on the specific document. The PAC will also discuss draft definitions of two of the terms council has mandated that the commission define: accountability and independent judgment. The commission will receive open public comment as well, and later in the agenda are next steps, including phase of work transition conversations. So please note that this meeting may run long. Hopefully not, but it may.
Thank you, Co-Chair Ajay. Now, I'm gonna pass our next item on the agenda is the review the draft PAC areas of agreement on officer accountability. referred on February 2nd by Subcommittee on Officer Accountability to the full PAC. Please, the co-chairs, Dan and Charlie, I will pass it to explain the document.
Okay, so I think I'm Dan Handelman. I use he, him pronouns, and I'm a member of the commission. I'm co-chair with co-chair Michelle Wesley of this subcommittee that is presenting this document to all of you and to some people in the audience who've seen this for the first time. We have a flow chart to sort of explain the flow of work that we're asked to propose for the city for the new board that's supposed to be going into effect. This is an updated version with little colorful backgrounds. I really want to thank facilitator Laura and her organization for doing some updates. I stole some of the ideas and put them in here to make this a little bit more flowy, I guess. So just very briefly, what we're looking at here is what happens at the beginning, where there's an incident between an officer and a community member, and that community member gets assigned an advocate. There's a preliminary investigation that has 3 possible outcomes and a 4th one that will lead to a full investigation. If you scooch over to the right, you'll see what happens if there's a police officer who has a complaint against another officer. They can decide to go through the internal process or to file with the board, in which case the same intake process will happen. Okay, let's move back over to the left and we'll flow down. And then we get to the full investigation, which I think I'm viewing this too large. The full investigation, which could be branch off and have a separate criminal investigation by other people who aren't the new board, because they're not authorized to do criminal investigations by the charter, and that should lead on to a hearing. That'll be the next section down there with the 3 on it in the yellow background. And so that hearings process starts with a preliminary hearing to make sure that all the information is available, and then goes to a full hearing where either some or all the allegations have substantiated findings or none. And if there are non-substantiated allegations, the complainant can appeal, which we'll get to in a minute, or if there are substantiated ones, it goes on to the discipline process, the red box below, where the officer, due to the fact that they're an employee, has 4 options of how to appeal. They can also accept the discipline, which we'll be talking about tonight in great detail. And then if we scoot over to the right, we'll see what the appeals process looks like. And that's for either the civilian or the officer. They can file the appeal, and at that point, the board can either agree with the original finding, they can change the finding, or they can send it back for more investigation. And if there are new findings of misconduct, then that goes back to the discipline process. And thank you. That was a very quick walkthrough of the flow chart. You need to spend a little longer than last time. And we got through, so there are basically 6 aspects that we're asked to look at in this document. We got through the middle of the 3rd one, which is the findings phase. So we can stop sharing the screen on this one now. So we had A, B, C, D, E, and F, and we got through C3. And so we're going to start again tonight with C4, which I believe my co-chair is going to read for you all for your approval. Oh, boy, before I turn this over, I forgot to mention at the last meeting that the other members of the subcommittee were Commissioner Iona, Commissioner Husseini, Commissioner McDowell, and Commissioner/co-chair Oriana Bauer. And I just want to make sure to acknowledge all the work that they helped put into this document. Thank you.
Right. Thank you, co-chair Dan Handelman. I am Charlie Michelle Wesley, co-chair of this Officer Accountability Committee, and I will start here on C4, where we left off, providing information to complainants and officers.
I'm sorry, Co-Chair Charlie, we need to, before we start, we just need to move and say, we ask you to follow our normal discussion rules. Please be brief each time you speak. Even if you can speak multiple times, please be facilitated, and remember we're now using a weighted stack in our discussions. Finally, please be forward-looking in your comments. We will be reading the section in full, then asking if there are any questions or proposed changes. If there aren't any, we ask and we'll move on and move to the next section. If there is proposed changes, we will discuss them, then ask if there is a consensus, and when all these are either resolved in some way or flagged for further discussion, we'll ask and we'll move on and move to the next section. Now, I'm sorry, now I can pass it to you, Co-Chair Charlie, to start the discussion.
Thank you. All right, ready? All right, C4, providing information to complainants and officers. A, board staff shall distribute information to involved parties before the hearing. B, screen's catching up. Hold on. There we go. B, an investigative report will be sent to the complainant, officer, and their identified support persons no less than 14 business days before the hearing. B1, the complainant and officer shall be given access to the same information as allowable by law. There is a footnote there. B2, any information that is provided to the officer but not the complainant shall be shared with confidentiality protections with the complainant's advocate. Let's see, C, following the decision of the board, the findings shall be shared in writing or other means if requested with the complainant and officer.
Thank you, Co-Chair Charlie. Is there any discussion or questions about this section? No? Okay, can we move on? Thank you. We can go to the next one.
All right, so this is C5. And it's this is the kind of the part where we talked about whether if the officer just accepts the findings and discipline, and it's called in the current system, it's called stipulated discipline, and we wrote in parentheses, in which an officer admits to misconduct and accepts discipline. It's actually called stipulated findings and discipline, to be clear, to be exact. Okay, so I think I'm going to do A and B, and then we'll come back and finish up with the other ones. So A, to expedite the process, officers can admit to misconduct and accept the proposed discipline. Stipulating to discipline will not reduce the level of discipline imposed. And B, the officer may have up to 7 days to inform the board that they stipulate to the findings and discipline, thus waiving all 4 possible avenues of appeal to an appeals panel of the board, to the civil service board, through a grievance, or through a due process hearing.
Thank you, Co-Chair Dan. Is there questions or discussions about this section A and B for C5? Can we move on? Okay, let's go to the next one.
Okay, well, just before I read this, we did talk with Jared Hager of the Department of Justice, who kind of got us to make sure that we understood what stipulated discipline is all about. So we're starting with C. Staff, thank you. I didn't read that yet. Okay, so section C. The following categories of cases are not eligible for stipulated discipline. And this is pretty much from city code as it stands now. 1, cases involving alleged use of excessive force, including officer shootings and deaths in custody. 2, cases involving alleged discrimination, disparate treatment, or retaliation. And 3, cases in which the body determines discipline. The body which determines discipline does not agree to accept the member's proposed stipulation to findings and recommend discipline. That's really written awkwardly. The body which determines discipline in this case is presumably the board, but we have written it in a vague enough way so that there's some problem with that, that whoever it is can accept the stipulated discipline. Right now it's the chief of police, and the plans that we wrote alternatively could be the Human Resources Division. That can we get a reading on that before I go to D?
Okay, is there any discussion or question? Yes, Co-Chair Charlie?
I was just wondering if we wanted to continue calling the Civil Service Board the Portland Civil Service Board.
Okay.
That's above, you mean? Yeah, sure. And perhaps we should say an appeals panel of the oversight board to be clear which board we're talking about. Great, groovy.
Do we need to ask if we are okay with the changes? I can ask. Is there a strong opposition to changing from what it was to adding oversized in Portland? Is there a general agreement to changing for what it was to the new adding those words? Thank you. Can we move on? Okay. Thank you.
So now D.
Can you just pause for one moment? Our
Sure.
Spanish interpreters are here, so we just want to make sure that everyone knows. That you get the channel set up real quick. If you just bear with us a few seconds.
Okay.
Yeah.
Excuse me, who is the other Spanish interpreter?
Gabi.
Gabby, okay. Thank you.
Thank you.
Thank you, staff. Then we can go back to the document. And we approve the changes on B. And again, I'm gonna ask again on the C if we can move on to the D. Can we will move on to D? Okay, thank you. Let's do D.
Okay, so D, the following categories of investigations are eligible for stipulated discipline. First-time offenses that would not ordinarily lead to discipline of more than 1 day off without pay. That's subsection 1, and subsection 2, second-time offenses that would only lead to command counseling or a letter of reprimand, which are the most minor forms of discipline, just for the record. E, an investigation involving multiple potential violations. The violation with the highest category from the city's should be corrective action guide will be used to determine whether the case qualifies for stipulated discipline. That's just something that got changed in this past year or so. And then F, stipulating to out-of-policy findings and discipline does not remove the complainant's ability to appeal any other finding.
Thank you, Co-Chair Dan. I'm gonna make the question. Is there any questions or discussion on D, E, or F? No, then is there a strong opposition to changing from what it was to the corrective action? Is there a general agreement to changing from what it was to what it is now? Okay, thank you. Can we move on?
All right. So now we're in D.
And for D, well, go ahead, Co-Chair Dan, for the title, you can.
Co-Chair Michelle Wesley is going to do that. Yeah. So the title itself, there was a typo in the document, and then it gave us the opportunity to add the words corrective action after the word discipline. And so even though the charter refers to the board being able to impose discipline, we just want to make it clear that corrective action can be part of that discipline process too. So that's the proposal for the subject heading.
Thank you. I need to ask separate for the title because it's the proposed changes and what I will. Yes. Oh, Co-Chair Charlie, go ahead.
No, I don't have anything. I was just waiting for you to do that.
Oh, thank you.
Oh.
Is there a strong opposition to changing the title on D? Is there a general agreement to changing the title on D? Thank you. Can we move on? Okay, let's do the one. Go ahead, Co-Chair Charlie.
Okay, D1. How to impose discipline, application of the discipline guide. A, the board has the authority to issue disciplinary action up to and including termination for all sworn members and the supervisors thereof within the Portland Police Bureau. A1, because the Bureau of Human Resources has authority over every city employee, if for some reason the board is unable to directly impose discipline or corrective action, the Bureau of Human Resources shall enact the will of the board. A2, discipline may include various consequences for the officer, as well as education-based alternatives to promote a positive outcome and avoid employee embitterment.
Co-Chair Charlie, Commissioner Sima has raised his hand.
Yeah, room for feedback at this time.
Yeah, I was
I'm
going
not sure
to,
if I'm doing it out of turn.
I was going to pause there because I do have a note. And Dan, do you remember? Let's see, language. It says language from 2021 to 325 corrective action guide. Were we going to put something there in regards to
It looks
that?
like, yeah, it looks like staff added that footnote in. It had been accidentally left off.
Okay, all right, go ahead, Sima.
Hey, that's my family name though. So my dad's side of the family, they call me Samir, so it's a compliment.
Oh, okay.
Yeah, no, so for AI, because Bureau of Human Resource has authority over a city employee, if for some reason the board is unable to directly impose discipline / corrective action, how would that happen if for some reason we weren't able to impose it? Like, for instance, a clarifying question for me.
Right, I don't have a clarifying answer, so let's see if Dan does.
Yes, thank you, Co-Chair Charlie. Co-Chair Dan?
Well, I think you can guess, Commissioner Hussaini, what might happen. What might happen is there might be some people who are unhappy with the way the charter's been written, and they might say that there's no legal way for this community board to do this, and it might tie it up in court for a while. So even though I think all of us agree with what the charter says, if some people don't agree, we just wanted to have a backup plan in case that legal objection comes up.
Thank you.
So, well, my follow-up would be, would whatever decision maker would in that place of us making that decision, they'd be utilizing the same processes that we've created as well?
But to be clear, the way it's written is that the board will make the decision and then give that decision to the Bureau of Human Resources, and as the footnote refers to, the rest of the city government cannot interfere with the independent judgment of the board. So then they would just take the discipline that the board says and says, okay, officer, I know the board didn't have the authority to do this, but we're doing it on their behalf. That's what this means.
Thank you. Thank you. Then can we move on to B? Or is there any additional question? No? Can we move on? Okay. Co-Chair Charlie, you can do B and C. Or D.
Thank you. B, the discipline imposed must be consistent with the city's corrective action guide, including exceptions that are written into the guide. C, the discipline can note trends and take into account the officer's individual history. And I'm just going to go ahead and read D. The police bureau may not issue discipline less than what the board chooses to impose.
Thank you. You want to read the next one? The E and double E.
Okay. Oh yeah, it's D1. If the bureau wants to increase discipline, they need to appear before the board to discuss the reasoning. the chief or representative will have to describe the aggravating factors informing their proposal. And 2, the board has the authority to accept or reject the Bureau's proposal.
Thank you, Co-Chair Charlie. And Commissioner Sima, you have a question or comment? Go ahead.
Yeah, for let me get this off my screen. For B, including exceptions that are written into the guide. If somebody can clarify that for me as well, I'd appreciate it. Like, what does that mean? Like, have exceptions written into the guide during corrective action process.
Thank you, Commissioner Sima. And I know Co-Chair Ajay Harris. You can go ahead, Co-Chair.
I don't have an answer to that question, so if someone else does, they should answer that before I ask the question.
Thank you. Commissioner Co-Chair Dan?
Yeah, well, if you look at the corrective action, I'll post the link in once I find it. If you look at the city's corrective action guide, there are exceptions. You know, they carve out exceptions where there are mitigating factors and aggravating factors that you could raise or lower discipline in certain places, and there are certain unfortunate things that are written in that allows something that's an automatic firing offense to be mitigated if the chief or the board, and the board is actually mentioned in this document, agree to do that. So they, you know, whatever, they can't, the idea of this sentence is really they can't go outside of what is written into the discipline guide, because that's, city has agreed upon that with the bargaining units.
Thank you. Commissioner Sima, do you have an additional question or now or comment? You're okay?
Yeah, I mean, it's the answer is the right answer, and yeah, I mean, I don't like it, but it is what it is.
Okay. Thank you. Co-Chair Ajay?
Yeah, I'm now that I hear that about the D1B, I think that answers my question, which was about the next section about the punishment not being able to be higher than what the board what the board recommends. I was confused by that because I kind of didn't see the point of that, you know, because usually it's the case where, you know, the discipline like is too low, you know, and I know this is going to be a new system and all that, but I'm assuming now that that's written that way because of the way that collective bargaining is, and or something like that. I don't know. I was curious about why I think, is it on, are we on the right one? I think was it the next one? Yeah, no, yeah, may not issue discipline less. No, not that. The next one. Yeah, if the Bureau wants to increase discipline, they need to appear before the board to discuss the reasoning, and they have the authority to reject or accept that. Yeah, I was just curious why, if not, if it's because of the collective bargaining thing, I understand. But if it's something other than that, then I'd like to know.
Thank you, Co-Chair. And Commissioner Dan?
Yeah, Co-Chair Amici, I'm glad you're asking this, but let's see if I can wrap my head around this, so then I can say it out my mouth. So D, the basic premise of D is that Bureau may not issue discipline less than what the board says. So that's already said they can't do that. But if they want to increase it, they have to run it by the board. And the reason for that is sometimes there are internal disputes among the police where they're trying to get people who are whistleblowers and otherwise people who might be doing things that the community might support, and the police want to go after them and give them more punishment, and then the board has to be able to describe, well, okay, I mean, if you're saying that this person has a long history that we don't know about for some reason, and you want to increase the discipline because of that, then we'll agree with it. But if you're just doing this because you don't like this officer, we're not going to agree with that. So that gives them the ability to do that, to have that discretion.
Thank you. Staff?
Yeah, just going back to part B, I'm not sure that and maybe this is something to ask an attorney, but I'm not sure that the word exceptions appropriately describes a mitigating or aggravating factor. I just wanted to flag that to something to circle back to when we get to the code side on it. I think the other notes would more appropriately be described as exceptions, but just wanted to flag that as a word choice when the code change comes up, just in case there's a challenge there.
Thank you, staff. Then I'm gonna ask if there is any additional discussion or questions. If not, can we move on? Okay, then we can go to the next one. Or we need to correct now? Okay, we can go to D2.
All right, that means I'm up for this. All right, so D2 is due process and just cause rules, which are stuff that were specifically listed for us to include in our documents in the city council charge to us. So A, the discipline process shall be consistent with due process and just cause considerations. One, the state of Oregon defines just cause as, quote, a cause reasonably related to the public safety officer's ability to perform required work. The term includes a willful violation of reasonable work rules, regulations, or written policies, close quote. And just for the record, the footnote indicates, it says includes a willful violation. It doesn't say that's the only reason. So I think that's important for us to keep in mind. Subsection 2 is about due process. And this language is taken from a Supreme Court case that defined due process. And as we were going through this checklist, and do this in your own head, thinking back to everything that we've talked about, I think we've included all of this in the proposed process, but I'm hoping that I'm correct about that. So due process includes A, the right to a hearing, which includes the right to present one's case and submit evidence. B, the decision makers must consider the evidence presented. B, the decision must be supported by the evidence. D, the evidence must be substantial. In this process, defined as a preponderance of the evidence. E, the decision must be based on the evidence presented at the hearing or on evidence that's contained in the record and disclosed to the parties affected. F, the decision makers, in this case the board, must act on their own independent consideration of the law and facts and not simply accept the views of a subordinate, such as the staff, in arriving at a decision. And G, the board or body should, in all controversial questions, make its decision in such a manner that the parties to the proceeding can know the various issues involved and the reason for the decision made.
Thank you, Co-Chair Dan. Is there discussions or questions about this section? Okay, can we move on? Thank you. We can move.
I'm also glad to see that there's a couple of lawyers in the audience tonight, so I'm sure if they have some comments, I'm hoping they'll jump in. All right, so I guess we're on D. Due process includes the officer's right to a separate due process hearing, known as a lateral hearing. These hearings are required to be administered by the body imposing discipline, which in this case is the board. One, when discipline is imposed by the board, a panel made up of board members shall hold the due process hearing. Two, when discipline is imposed by the Bureau of Human Resources, one or more representatives of the board's panel shall attend the due process hearing to aid in deliberations.
Thank you. Is there any discussions or questions about this section? Let me ask the question, is there a strong opposition to changing, to adding these words? Is there a general agreement to changing and adding these two words? Thank you. Can we move on? Okay. Let's go to the next one.
I think we're on to E, but it's actually my turn still. All right, so E is appeals. and E1 says both the complainant and the officer have rights to appeal their cases. A, the complainant may appeal findings, dismissals, or decisions not to investigate. B, police officers may also appeal findings, dismissals, or decisions not to investigate. Sub 1, supervisors cannot file appeals on behalf of officers. And sub 2, officers may alternately file appeals with the Civil Service Board or Portland Civil Service Board, or initiate a grievance procedure, which may lead to arbitration. And then the subsections that refer to those are named in that. I'm going to pause there before we do C and D.
Thank you. Is there any questions or discussion from E? Commissioner Sophia?
Yeah, I just had a question about the arbitration. I know you have a footnote there. I did not read it, but I was just thinking arbitration sometimes has issues associated with it because the board, the people chosen for arbitration are, it depends on which arbitration organization or company is chosen. So I was just concerned about arbitration because there's some issues associated with arbitration as well. So just a question, if anyone has any comments, I'd appreciate it. Thank you.
Right, well, I appreciate that, Commissioner Glenn. And we do address arbitration process later on in E3C. So, but in brief, our solution to that is, and you'll see that when we get there, is to make it so that board members can attend the arbitration and make their case directly there. I hope that's helpful.
Yes and no. I don't know, but it's
Right, well,
good information.
Right, I understand. Well, this is a state, all of these, as I said when we were going through the flow chart, all of these appeals for the officer, the Civil Service Board, the grievance procedure / arbitration, these are, and the Loudermill hearing, these are all enshrined in law or in Supreme Court hearings, thus making them constitutional rights. So we can't take those rights away from the officers. What we can do is try to make it, as we've been trying to do with this whole process, level the playing field so that the board and the complainant have some say in what goes on instead of being shut out, which is what happens now.
So I have a question. Can the board be involved in selecting the arbitrator organization? That's my concern, is who's going to be the arbitrators. A lot of times our sympathizers with, depending on how it's gone or where it goes, it could be sympathizers with the police board. So you just don't know. A lot of them are past, judges and things of that nature. So is there a way that the board could possibly be a part of that selection of arbitration or something of that nature?
And Commissioner,
Well, again,
is there anything you want to add or suggest adding to that phrase? That way it feels more.
Yes, maybe we could say something to the effect, because I'm just thinking off the top of my head, the board be involved in the selection of arbitration members or something like that.
Thank you. And Commissioner Dunn?
Yeah, I believe we should put this into the bin of items for us to present for changes to the state laws, because that right now the state law describes who chooses those arbitrators, that we would have to change state law to make that possible. I agree with what you're saying, but I think that we can't write this into city code unless the state law is changed. So if it's okay, maybe, we have a couple of items, a very growing list of items for our garden plot for, state laws and other things we'd like to see changed. So is it okay with you, Commissioner Grant, if we put that into that bin for later discussion?
Yes, and while we're doing that, at the end, I will see if there's some other language I might want to add, just so we can move on right now. I'll just think about it and maybe come back if I have anything. If I don't, I won't say anything. Thanks.
Thank you, Commissioner Sophia. Then can Can we move on or you want, staff?
Yeah, the other thing to consider when circling back to this or when considering circling back to this question is whether or not this might be something that the oversight board itself would need to get involved in as opposed to the PAC doing so. Just a flag for later to consider, because the oversight board, as per the structural oversight document, would have the ability to recommend changes to state law and the legislative agenda. So thank you.
Thank you. Then are we flagging this section to go back at the end?
No, it was my
Okay.
understanding, and commissioners can disagree if I'm incorrect here. My understanding was that it was for later on in this process, not later on in this document.
Okay, because Commissioner Casey also has a comment on the chat. In suggesting that language. I don't know if that he's asking if it's a garden plot or is something that we can add here. Staff?
Yeah, the other thing is this might be itself structural oversight conversation. The proposed, which is just really quick. I'm going to be put again into the chat, but yeah, I'll pass it over to.
Okay,
Sorry.
thank you. Co-chair Dan?
Yeah, well, as I said, we discussed arbitration in section E3C, so maybe we can hold that comment and come back to it when we get there and see if there's a way to fit that in.
Okay, thank you.
We're just talking about the right to appeal.
Okay, thank you, Commissioner Dan. Then can we move on to the next? Okay, let's move on.
All right, so I'm going to read C and D together. C, the request for an appeal will include the name of the complainant or officer filing, date of the incident, and reason for the appeal. 1, the advocate provided by the board shall assist the complainant in filing the appeal form. And D, the board has independent authority to reopen cases when it is in the public interest. Reasons may be due to written, verbal, or other community opposition to a decision. And sub 1, suggestions for the board to reconsider a case may be made by a vote of City Council.
Thank you, Co-Chair Dan. Is there any discussion or question? Is there discussion or question about this section? Can we move on? Okay, thank you.
Okay, so E is timelines for appeals, and this is where we're going to get to these other issues. First is E. A request to end an appeal may be made at any time, but withdrawal should be done in consultation with the advocate and may include confidential information. If practical and appropriate, the appeal might still proceed without the complainant.
Is there a discussion or questions about E? Can we move on? Thank you. Oh,
Okay.
I'm sorry, Commissioner Sophia, you raised your hand to say we can move on. I'm sorry. Go ahead. Next is E2.
So there is no question?
Oh, I don't know. Commissioner Sophia?
No.
Thank you. No. Commissioner Charlie,
Okay.
thank you.
Thank you. E2, timelines for appeals. A, community members have 30 days to appeal, but exceptions can be made to extend the timeline. A1, the board may adopt rules for permitting late filings up to 60 days for reasons including, but not limited to, A, the complainant has limited English language proficiency. B, the complainant has physical, mental, or educational issues that contribute to an untimely request for review. B, the timeline for officers to appeal is 30 days, with only limited exceptions allowing up to 60 days if they are incapacitated or unable to receive or send information to the board. and C until the appeal period has expired. And if an appeal is filed until there is a final decision by the board, the city may not enact proposed discipline.
Thank you, Co-Chair Charlie. Is there, yes, Commissioner Fate?
Hi, yeah, just a language proposal for AIB.
Okay,
The complainant has physical, mental, or educational, maybe accommodation needs instead of issues. Thank you.
thank you, Commissioner Fate. Commissioner Casey?
First of all, thank you, Commissioner Faith, for suggesting that change. The other thing that I wanted to raise was I find the language may adopt rules for permitting late filings up to 60 days confusing. I don't know if that's trying to say up to 60 days after the original 30 days or up to 60 days total. So I think we might want to clean up that language a little bit.
Thank you, Commissioner Casey. Do you have any suggestions?
I will drop some language in the chat because I think I'm better trying to type out language than trying to come up with it on the fly.
That sounds great. Thank you very much. We appreciate it. Any additional discussion or suggestions for A, B, or C? Commissioner J, Co-Chair J?
Yeah, I mean, I just, just as like a slight change, it's saying the complainant needs physical, mental, or educational accommodations, as opposed to saying has accommodation needs, because just I never really have heard that kind of language, has accommodation needs, but I have heard it's like that someone needs something accommodations. Yeah, just one suggestion.
Thank you. Okay, Commissioner Sima?
Yeah, I so when it comes to educational accommodation needs, I'm still a little vague on that. Like, yeah, I'm sorry, it might be me working pretty slow, but
That's okay.
somebody can kind of clear that up for me, please.
Yes, Commissioner Monica has raised her hand. Commissioner Monica?
Yeah, I would, educational accommodation needs, what comes up to me is things like ADHD, and other situations where people need a little more time to go through a complicated process, right?
Thank you.
I mean, sorry, just to kind of continue with that. I mean, that I don't know, and maybe Commissioner McDowell can, if is Commissioner McDowell here? Yeah, if Commissioner McDowell can elaborate on like how one's cognition would come into a process like this, whether there's like a barrier, how that gets disclosed even sometimes, because sometimes it wouldn't be, and how do you provide that opportunity for that to be acknowledged? And so I just feel it's real complex to me to see this as accommodating as it is. I don't want to set us up for failure as a board.
Thank you, Commissioner Sima. I will pass it to Commissioner Fate.
Yeah, in response, I understand your question, Seema, but I think, and I agree with the edits that Co-Chair Ajay made, so I'm good with just changing it to accommodations. And I think the way that it would come up is, I mean, I don't think we need to get in like to ADA law, but if someone had an intellectual disability and needed accommodations to participate, they could request accommodations. So I think just leaving it under the title of educational accommodations implies that. So that's my interpretation.
Thank you, Commissioner Fay. I know, I will pass it to Commissioner Charlie and then Commissioner Catherine and then Co-Chair Dan.
I would like to defer to those two first in case they might answer the
Okay.
question. Yeah.
Thank you, Co-Chair Charlie. Commissioner Catherine?
Yeah, just to respond to Simab's question, I think what we were contemplating is that typically if somebody needs more time, either because they've missed the deadline or they just are not going to make it, that they would file something with the board asking for more time and stating the reason why they needed it. And I think typically you would say, you know, there's good cause for additional time, and the good cause here consists of, you know, for example, I have limited English proficiency, or I have, you know, a disability that requires that you know, made it more difficult for me to meet the initial 30-day timeline. So I think it would be up to the complainant to establish the basis for needing that time, and they would be in the position of volunteering the reason why they needed that time. Thank you.
Thank you, Commissioner Catherine. And I want to notice that we have less than the 5 minutes rule for discussion. If we cannot, we need to go back to here, but I will pass it to Co-Chair Dan and then Commissioner Fay. Oh, Commissioner Charlie, you also want to go? You can go now, Commissioner Charlie.
Oh, I just wanted to mention this might come into play to soothe some people's concerns that I'm assuming their advocate will be on board with advocating for them when it comes to these issues. At that time, I know someone brought up the fact that, like, what if it's not known? Well, I think the advocate would be able to do something about that at that, knowing the complainant better than anyone in the process, right?
Yes, thank you, Co-Chair Charlie. And let's just, I need to ask for consensus on B, and then we can go to the other part. Is that okay with you, Co-Chair Dan? I'm gonna ask, is there a strong opposition to changing the B at what is suggested? Is there a general agreement to changing what it was to what is suggested now? Okay, thank you. At least we approve B. Now we can move to the other, and Co-Chair Dan?
Yeah, well, just for the record, the footnote on that item we just cleared says that this language, the original language, came directly from City Code as it is now. Okay, so in sub 1, Commissioner Lewis has proposed some language, which I helped. We sort of were going back and forth in the chat, but I think this will work. The board may adopt rules for permitting late filings for a total of no more than 60 days. And then I would suggest adding a similar language in B, in subsection B, that says officers with only limited sections allowing for a total of no more than
60 days.
That's there you go. Thank you.
Thank you. Then I'm gonna ask for IMB and say, is there a strong opposition to changing from what it was to what is now? Is there a general agreement to changing for what it was to what is now? Okay, thank you. Can we move on? Oh, yes, can we move on? Okay. We don't have anything on C. Can we move on about C, or there is question or discussions? Can we move on? Okay, next one, E3.
Let me know when it's time to take a break, but there's 10 subsections in E.
Oh, wow. Okay.
Yeah,
maybe we can do, I don't know, it's up to you. Maybe we can do let's work on E3 and then we just take a break.
Okay. E3, appeals hearings. A, appeals will be heard by a different panel of board members than heard the original complaint, except in cases in which the basis for the appeal is the discovery of new information. In either situation, this will be referred to as an appeals panel. 1, a certain number of board members may be assigned to a board appeals committee whose main function is to hear appeals. 2, if a member of the original panel is unavailable, a board member or appeals committee member who is not part of the original hearing may be assigned to the hearing. 3, if there are not enough members of the appeals committee for a quorum, members of the full board who did not hear the original case may be assigned to the hearing. 4, in the case an appeal is based on the discovery of new evidence, investigators will confirm the validity of evidence prior to an appeal hearing, and that relates to something we talked about at our last meeting, where we want to make sure that new evidence that's introduced gets verified. And then 5, the board may select a subset of between 2 to 5 members to process appeals of dismissals or decisions not to investigate. And this is really important. This is highlighted and underlined because this was just added today by myself and the co-chair, Michelle Wesley. Again, as we're going through the flow chart, and if you looked at the earlier part of the appeal section, it says there you can appeal the findings, or you can appeal dismissals, or you can appeal decisions not to investigate. And this sentence is to make it so that they don't necessarily have to hold a formal appeal hearing when somebody's just appealing a dismissal or a decision not to investigate. That's the proposal there.
Sorry, thank you, Co-Chair Dan. Is there questions or discussion about E3A? Staff?
Yeah, could co-chairs Charlie or Dan explain, because this was a question at the subcommittee, it might be here, the difference between an appeals panel and the appeals committee that are mentioned in the document in 2 different places.
Yes, thank you.
Yeah, the appeals panel is the people who are hearing the appeal. An appeals committee is a potential, and it's listed here as a potential that can be further fleshed out in the next phase, but a potential subset of the commission, or of the board rather, that would be focused on hearing appeals instead of being part of the ongoing hearings of perhaps 400 cases a year. They'd be listening to the appeals, would probably be a much lower number, but there'd be specialists in the appeals, much like the Citizen Review Committee is now. That's the concept behind it.
Thank you, Co-Chair Dan. I will pass it to Commissioner Sima.
Thank you. In concept, it's really understandable, but it sounds real messy because they're so closely labeled. Yeah, that's my opinion.
And
That's it, sorry.
Commissioner Sima, do you have any suggestion to make it more clear?
I don't, I'm sorry. There sounds like, it just sounds like there's a redundancy in there somewhere that I just can't pick up, and I don't know how to resolve it.
Okay, thank you. Is there any additional changes or questions about this comment? I know there is a proposed change on number 5 that we need to review. But yeah, Co-Chair Charlie?
I'm just wondering, and I'm talking to my co-chair, is it possible to explain that the appeals panel is like a something of the appeals committee? I don't know. I'm just trying to help make it clear.
Well, the issue is, Co-Chair, that if the appeal is being heard because the original board members who heard it didn't hear some evidence, then they can just go on and hear the appeal. But if there's no new evidence and the person just says, I disagree with your finding, then you don't want the same people listening to it again. That's because they'll probably come to the same conclusion. So there's a separate people. So either one is, in the way we've written this, is called an appeals panel. It's just that they may be made up of different kinds of people. So that's
And maybe helping will be to have the definition of both the footnotes, footnotes. Okay, I'm gonna ask if there a strong opposition to changing what it is here in E3. Co-Chair Charlie, you have your hand raised. Okay. Is there a general agreement to changing from what it is and adding the number 5? Okay. Thank you. It is 7:44. Let's take a break, and it's 7:45 now. Let's take a break and come back at 7:50 to continue with EB. Thank you. Thank you. Okay. We can continue.
Okay. Where were we? E3B.
Yes.
E3B. If an officer chooses to appeal to the city's civil service board, the hearings panel shall receive a copy of the appeal and provide a written statement about the misconduct and supporting evidence. In sub 1, one or more hearings panel members may attend the civil service board hearing, subpoena witnesses, present evidence, and cross-examine.
Thank you. Is there any questions or comments? And I know there is a proposed change, but I want to see if there are questions or comments. No. Okay. Is there a proposed change here? Then I will ask the question, is there a strong opposition to changing from what it was to what the addition is here?
As a point of clarification, it's a very minor change in the footnote that it's talking about the Portland Civil Service Board, and we just changed the language to say the Portland Civil Service Board and cross out parentheses board because it's not referred to anywhere else that way. So very, very minor.
It's minor, okay. Is there, but I still need to ask, is there a general agreement to the change? Okay, thank you. Can we move on? Thank you.
Okay, so E3C. If an officer chooses to file a grievance and an arbitration hearing is held, the hearings panel shall receive a copy of the grievance and provide a written statement about the misconduct and supporting evidence. And then sub 1 is that the hearings panel may have one or more representatives attend the arbitration hearing to present evidence and answer questions about the findings.
Is there any questions or discussion in this section? Do I need?
So I should,
Yes.
so Laura, this is where you know, Commissioner Lewis's proposal would go. So if we wanted to put in a sub 2 that says, to the extent allowable by law, board members shall be involved in selecting the arbitrator.
Okay, thank you. Well, we'll wait for staff to add it. Thank you, staff. Let me ask this. Is there a strong opposition to changing from what it was to what is now? Is there a general agreement to changing from what it was and adding what is happening now? Okay, thank you very much. Can we move on?
Okay. So D, to the extent I'm going to read D, E, and F together. D, to the extent possible, the complainant will be allowed to attend or at least remain apprised of appeals held outside the board's direct scope and authority with their advocate assigned until a final decision is made. E, at an appeal hearing, decisions on the findings shall be made on a preponderance of the evidence, which we defined earlier. And F, all members of the appeals panel shall review recordings and other records of the original hearing.
Thank you, Co-Chair Dan. Is there any discussion or questions for D, E, and F? Can we move on? Oh, Commissioner Catherine, do you wanna comment?
Yeah, I'm sorry, I was just thinking about the last change and so maybe it's too late, but maybe this change is unnecessary, but I wondered if we need to say to the extent allowable by law and applicable collective bargaining agreements. Because I was thinking that arbitration is to some extent controlled by the collective bargaining agreements. So we might need to have that provision in there as well. Thank you.
Then you're suggesting to add that. Okay. Thank you. Commissioner Monica, is your comment for this specific section or the next one? No? Okay, I'm gonna ask again for this specific section. Is there a strong opposition to changing and adding our collective bargain agreements?
I think it should actually be an applicable collective bargaining agreements.
Thank you.
Thank you.
Thank you. I was about to ask a question about that, and that completely cleared it up.
Oh, thank you. Thank you, Commissioner Sima. Commissioner Casey, are you going to comment for this specific change or for the next, the D, E, or F?
This specific change.
Okay, go ahead, Commissioner.
I would say that my only concern, and I think probably this language makes sense, but my only concern is putting things into whatever our proposal in the city code is that binds the hands of this board because they say our rules say that we're subject to the collective bargaining agreement. I'm sure if the PPA believes that the collective bargaining agreement is controverted by something that this body does, they will be all too happy to make that argument themselves. But I'm not sure how putting that into this document does anything other than potentially sort of put this board in a bind of having to sort of, you know, if there's a disagreement between state law and the collective bargaining agreement, having to sort of try to serve both.
Thank you, Commissioner Casey. And do you have any suggestions? And then Commissioner Sophia agrees with you.
I would just leave out the part with and applicable collective bargaining agreements.
You're suggesting to cancel, eliminate and applicable collective bargaining agreements. Is that clear? Yeah, is that what you mean?
Yes.
Okay, I will pass it to staff.
Yeah, just to clarify, that's not in the document yet. So it would be strong opposition to the addition
Okay.
of and applicable collective bargaining agreements, just to clarify a process note here.
Yeah, I agree with the addition of everything else that is not yet in the document. I just would not want to add that part as well.
Okay, then I'm gonna ask the question, and when I ask the question, is there a strong opposition? We'll see. Or yes, I can ask the question, but Commissioner Catherine.
So I guess the reason that I thought it was important to have this here is that I think the selection of arbitrators for an arbitration process that's outside of our, you know, the scope of the oversight board is you know, it extends, I think, beyond what the literal charge that's contained within the charter amendment. And I think that it's fine to do that, but I think we need to be cognizant that the charge does, the charge in the charter amendment or pursuant to that is very clear that what we're recommending needs to comport and comply with applicable laws and the collective bargaining agreements. And so I guess I just feel like because this one is going really further than just strictly designing the civilian oversight authority, and we're going into an arbitration process that's really outside of the scope of what we're doing, that we should be careful that we're not trying to extend the scope of our authority beyond really what we've been given by the city. So I'm just conscious that doing that makes our work vulnerable to attack. So that's why I put that. That's why I suggested that information, because I feel like the statement itself is far-reaching, or the proposal itself is kind of far-reaching. So we need to be careful about how we're proposing it. Thank you.
Thank you, Commissioner Catherine. I will pass it to Commissioner Simab. Oh, it's not. Commissioner Simab, do you have anything to say?
Well, this is on the point that Commissioner Lewis was making, so I definitely would rather. I think the point, what the discussion that's currently taking place is what's benefiting my questions.
Okay. Thank you, Commissioner Casey, and then I will go with the staff.
Sorry, my hand was left over.
Okay. Staff?
Yeah, with respect to the merit, nothing to say there of this idea either which way, in it out with a proposed change, but did want to mention from the perspective of where this fits, it doesn't exactly relate to the remainder of this section or document to talk about what is ultimately a structural question, which is, does the board have the authority to be involved in the selection of arbitrators and through a process of this nature? So noting the previous comment that this may be something that the oversight board itself would want to talk about, if the commission were to do it, it seems to me to make more sense in a different document, in the structural oversight document, if in any capacity. And that might also save some time today, just because this is not really about the individual arbitration, unless the question was about selecting which arbitrator is chosen from the grouping for the thing, which is I don't believe that's what the intent of the text was, but Commissioner Casey could probably clarify if that was the intention. But yeah, if the intention was that, then that might fit in here. But if it's about selecting the pool of arbitrators from which an individual arbitrator would be chosen from for a specific situation, that seems more structural oversight. Just wanted to mention that.
Thank you, staff. I will pass it to Co-Chair Dan.
Yeah, okay. My proposal is to leave this the way it was without the applicable collective bargaining agreements, because the overall charter says that the board is authorized and has to meet legal obligations under the Public Employees Collective Bargaining Act. So if it is subject to that, that's part of being allowable by law. So I think we can just cut that out, but it's still inherent in that statement. So I'm hoping that Commissioner McDowell will be okay with that, because we already approved of it written that way, and then we can move forward.
Okay, are you gonna?
Just bear with the changes for a second. It's going to look like things are being deleted, but they're not.
Okay.
I'm unable to see Commissioner McDowell on my screen. Is there an agreement that's okay?
And I will ask the question because we need to move on, and it doesn't have to be everybody, but we'll see who's the consensus. Okay. Is there a strong opposition to changing or to adding as looks now. Is there general agreement to add an applicable to the extended allowed by law and applicable collective bargaining agreements? Yes, commissioners, oh, everybody says agree, okay. Then can we move on? Oh, staff, I'm sorry, maybe I just asked.
I think, yeah, I apologize. I think I saw a hand come up late for strong opposition there, as opposed to, yeah, I don't know that that constitutes consensus. Apologies. For
Okay.
that. Yeah, if you could maybe ask a little slower, if the question is whether or not there's strong opposition to adding this particular section.
Yes.
5 words here.
And if there's strong opposition, yes, Commissioner Catherine?
So I wonder if we should be, I mean, where do we get the choice of just tabling this language for now? Because I'm not sure that the binary up down gets us to that potential solution, which is just discussing this whole issue about selecting arbitrators as a part of the next phase of work. It seemed like that was what staff was proposing, and it sounded like Commissioner Casey thought that was a reasonable outcome as well.
Thank you, Commissioner Catherine.
To clarify, not the next phase of work, just not in this document specifically, maybe for a revisitation of structural oversight or something like that, which would come later, but yeah. And that's a proposal. You're allowed to propose that exact tabling. And so I think you just did, Commissioner Catherine. So we could discuss and or ask for consensus on that proposal.
Okay, is there a strong opposition to agree to the consensus to the proposed that Commissioner Catherine suggested? Is there a general agreement to the proposed what Commissioner Catherine has suggested? Okay. Thank you. Can
Okay,
we?
so if I'm understanding that correctly, that entire sentence is no longer in the document. Is that correct?
Correct.
Okay. So D, we did D and E. So F, I think I did F also. I didn't write this down. Did I read that one? All members of the appeals panel shall review recordings and other records of the original hearing. I don't think I did.
And
Okay.
if I remember correctly, Commissioner Monica has a question about others, or no longer that, Commissioner Monica?
Yeah, no, so
Yes, but I am completely lost as to where we are.
Okay. Coach Sheridan, can you read the EF again? Or is
I found it. I've got it.
Okay, I'm sorry, Commissioner Sheridan. Commissioner Monica.
On F, could we clarify a little bit more and make sure that the appeals panel is looking at all of the records? So.
Okay.
So that they're looking at all of the evidence.
Okay.
That's all.
Thank you, Commissioner Monica. Is there any other suggestions about D, E, F? Okay. Is there a strong opposition to changing F and adding the all on F? Is there a general agreement?
I'm sorry. KC Lewis recommended all recordings and records of the original hearing, and I think that's better.
Okay, all recordings and all. Okay, I'm gonna ask again.
Sorry.
No, it's okay.
That.
Go ahead, Coach.
The current way the system works is that the people who are reviewing these cases aren't required to listen to all the recordings. They can choose to do so. They just have to read all of the records. So I wouldn't want to put this extra burden on the new members of this new board. So I strongly oppose putting all in front of recordings and just leaving it in front of all records.
Okay. That was a suggestion. Is there Commissioner Sima?
Yeah, I would say that having the word all again in there would be redundant. So I agree with Commissioner Handelman on that. And I think that, you know, all recordings and records, it can infer both as well.
I think perhaps you misunderstood me. I think we should say shall review recordings and all records of the original hearing, so that they're not being forced to listen to all the recordings, but they are forced to read all the records.
See, the way I was reading it, it can infer both. And that's, so if you don't want it if you don't want them to or have to mandate them to read all the records of the regional hearing, then I would say that we have some wordplay stuff that could be probably yeah, messed with down the road or cause confusion.
I have a feeling we're having some communication issues here. I think what I'm suggesting is to say all members of the appeals panel shall review recordings and all records of the original hearing as Commissioner Arce presented. I do not think we should put all in front of the word recordings, because they can take up hours and hours and hours and hours of the volunteers' times, or perhaps they'd be paid, but we don't know that yet. And it's just, it's a more thorough review when you listen to them, but it's not necessary. That often they have transcripts of these and they just have to read them.
Okay, the suggestions that we have 2 suggestions here. Staff?
Yeah, Commissioner Monica, it was your original proposal to add it in, and then you, maybe it might be a staff mistake to assume that you wanted to move the all forward. Where would you like it to be?
I think Commissioner Handelman makes a great point. If reviewing all the recordings and all the records is asking for too much from possible volunteers, and they are going to review all the records, I feel okay with that.
Okay, so then there's just one proposed change, which is to change other to all, and I'll pass it back to Victoria.
Yeah, thank you. But then Commissioner Sima say it shall have access to review all. It's true. Commissioner Sima, do you wanna put that? They should have access to review. They don't have to, but they should have access to review all recordings if needed.
Yeah, I mean,
Oh, Commissioner Sima and then Coach Dan.
well, actually, I would love to hear from Commissioner Handelman.
Okay. Coach Dan?
Yeah, so this instruction comes from existing city policy, and it's just it's instructing them that in order to hold the hearing, they have to review the evidence. It's not saying anything about their access to them. It's saying that they need to review the evidence before they go to the hearing. So I don't know if there's a better way to write it than that, but that's the meaning of it. The fact that they have access to it is not in question here.
Okay. Thank you, Commissioner Dan. Commissioner Sima, are you okay with that?
Yep.
Okay, then I'm gonna ask, is there a strong opposition to changing what it was to what is suggested? Is there a general agreement to changing for what it was suggested? Thank you. Can we move on? Okay, next, G.
Well, I guess I'll just read G so we don't have to split a page. So G, appeals hearings shall follow the same procedure described in the findings section on hearings, which we did last time, including for disciplinary decisions. The panel may expedite matters by not repeating information already in the record.
Is there a, thank you, Commissioner Co-Chair Dan. Is there any question or discussion about G? Can we move on? Okay, next, thank you.
Rest of G. Sub 1, at the start of the hearing, the basic circumstances of the case, allegations, and original findings will be read into the record. 2, at the end of the hearing, the appeals panel may decide A, to recommend further investigation, or B, to affirm the original findings, after which the board staff shall close the complaint based on those findings, or C, to determine a different finding based on the evidence and make disciplinary decisions if there are findings that the officer violated policy.
Thank you, Co-Chair Dan. Is there a discussion or questions about G, I, double I, 1 to A, B, C? Can we move on? Okay, thank you. Next.
All right. H, I, and J. Let's do these all together. H, members of the appeals panel shall have the same authority to compel officer testimony and subpoena witnesses or documents as the original hearings panel. I, notifications of the appeal outcomes to complainants and officers shall be the same as under the hearings process, which is section C4C, I think, with the exception that no further appeals are allowed through the board. And J, the board staff shall schedule appeals in consultation with the board leadership or designee.
Thank you, Co-Chair Dan. Is there any questions or suggestions about H, I, and J? Can we move on? Thank you. Next.
Oh, it's me again. Okay, I'm going to take a little breath. Oh, so F, this is the section on mediation. Now, this isn't in the flow chart. It's in the flow chart at the very top. So this would happen after the intake, preliminary intake is done, and if it qualifies for mediation. So this is not, you know, in terms of flowing, it's not the next step, but it's just an alternative step that we haven't addressed yet. So back to the F. Yeah, thank you. F1, there shall be a voluntary mediation program between complainants and officers. Sub 1, the board has the authority to provide for voluntary mediation between community members and law enforcement. 1 sub 1, I think that's supposed to be A. No, I don't know. It's all very confusing. The goals of mediation include improving police-community relations and building better policies. And sub 2 is the board shall determine, thank you, the board shall determine whether the case is eligible for mediation based on substance and the nature of the allegations and the officer's histories. And then the subsection, so that subsection are A, the community member shall be able to consult with their advocate and or their other support persons before making that decision. That A doesn't belong there. Oh no, the decision whether to agree to mediation. I'm not sure how that all got toggled up, but making the decision whether to agree to mediation. And B, complainants shall not be unduly pressured to choose mediation if they prefer an investigation to take place. And C, the officer has to be cleared for approval by the officer's supervisor before the officer can agree to mediation. An officer's supervisor must clear them for approval before the officer can agree to mediation.
Thank you.
It feels like that's two versions of the same sentence, and one was supposed to be crossed out. I'll see what I can find while people discuss.
Okay, do you have any discussions or questions about? No?
Okay, well, maybe we can just come back to that, and I'll turn it over to my co-chair.
Yes. Co-Chair Sophia?
Is there another subsection here that I didn't think about? Thank you
Okay,
for having my screen up.
okay. Commissioner Sophia, you were gonna say?
And I was just a minor proposal change for the, I can't see the document anymore. Instead of the, I know we changed from that, other support person before making a decision, whether to agree to mediation, that's all.
Thank you.
Thank you.
Okay. Thank you. And there is 2 proposed changes, but I'm gonna take it to 1. I'm gonna pass 2 with the same questions. Is there a strong opposition to changing for as it was as to what it is now? And is there a general agreement to changing what is now? Thank you. Can we move on? Okay. Staff.
Yeah, just to clarify, what Co-Chair Dan mentioned is correct. The 2 sentences were 2 different versions of the same one, so apologies for that. The first one was replaced by the second one, so the track changes you're seeing reflects them. Thank you.
Thank you. We don't need to ask the question. We can already ask the question and we can move to B.
Great. And again, my apologies. I was trying to look for that while not looking at the screen, so I didn't realize I'm still up. So B, mediation is not offered for complaints involving use of force, profiling, legal violations such as improper stop, detention, search, or arrest, or for officers with a pattern of misconduct. No case identified as an automatic investigation by the charter shall be eligible for mediation. Sub 1, mediation is offered for complaints involving discourtesy and procedural complaints, including unwarranted action other than those described in section F1B and neglect of duty. 2, if the complainant filed the misconduct complaint based on actions which arose from an incident. I think there's more crossing out stuff that didn't happen here. If the complainant, do you still have that original document pulled up, staff?
Yep, just a second. Yeah.
So can you figure out what we're supposed to say there?
I see what happened. Got it.
Okay, thank you. So it says, actually correctly, it says, if the complainant filed the misconduct complaint based on actions, oh, nope, it looks like it's the same thing. Oh, based on actions during an incident, thank you, woohoo, in which the officer filed criminal charges or citations against a community member. Once those criminal allegations have been resolved, mediation about the misconduct complaint can still proceed. So those aren't actual. The only actual change we're asking from the draft that you should have seen, and what we approved at the subcommittee is that RE shouldn't be there. So it should say, one more time, if the complainant filed a misconduct complaint based on actions during an incident in which the officer filed criminal charges or citations against the community member, once those criminal allegations have been resolved, mediation about the misconduct complaint can still proceed. And 3, if there is a civil lawsuit or criminal case against the officer, mediation cannot proceed.
Thank you.
C, discussions that take place in the mediation are confidential unless the parties agree otherwise.
Thank you. Because the changes were just errors, no need a vote. I just say, can we move on? Oh, Commissioner Sophia, you have a question.
Yes, this is just a question for the group. As it says in B3, it says if a civil lawsuit or criminal case against the officer, mediation cannot proceed. Is it possible to have mediation after it's closed, the incident? I know there's a lot of closure issues that people may have, especially if a civil lawsuit comes up. Just wanted to know if that's something that can be an option or if there is some reason why it can't be. That's all.
Thank you, Commissioner Sophia. And staff is showing more information. Okay. Is there any
Really?
yes, Commissioner Casey?
Oh, where are we? What are we discussing right now?
We're discussing what Co-Chair Dan read, and then Commissioner Sophia did ask a question about B3. And we're discussing B3, but I don't know if you have any additional discussion in other area besides.
No, I also wanted to discuss B3, so that's good. I was right on. As it's currently worded, it sounds like that mediation can't proceed if there is any civil lawsuit or criminal case against the officer. And I don't know if maybe we want to clarify that to say that, you know, when suing the officer over the boundaries of their property or something, that doesn't mean that they're then not able to be involved in the mediation process at all.
Thank you, Commissioner Casey. And you were talking, the sound when broke a little bit. I don't know if you want to repeat it or you want to put it on the chat.
I think I can offer some language. I understand what the commissioner was talking about. So if there's a civil lawsuit, criminal case against the officer about the incident.
Okay, thank you. Is that reflects what you were saying, Commissioner Casey? Oh, he put something on the chat to add it, that suggestion, and the staff is gonna work on it. In the meantime, I'm gonna pass it to Commissioner Faith.
Yeah, I think I just want to go back to what Commissioner Sophia mentioned. I think this resolves a separate issue, but not the one Sophia mentioned, which to me is the problem of, okay, so if there is a civil lawsuit or a criminal case from this incident, if that resolves in nothing, like if the criminal case or the civil case resolve in nothing, can the complainant still proceed, start, because those are closed?
Yeah.
They then could approach mediation. Question mark. Is that what this is to imply? Or is it saying they can never utilize mediation?
Thank you. And I will pass
Yeah,
it before Commissioner Dan, let me just pass it to Commissioner. Thank you, Commissioner Faith, to Sophia again, and maybe she wants to clarify something, and then to you. Commissioner Sophia?
Yes, thank you. And I appreciate that, Commissioner Faith, because that was another portion that I didn't even think about, is like, if they didn't get the result that they wanted, but even if they did get the result that they wanted, I think there's, this has just been my experience. Some people do want to talk to the folks about it. And I just wanted to leave that open to give people opportunity if they wanted to, after it's closed, to do mediation for whatever reason. I just think maybe it should be open for that, just for some closure. Thank you.
Thank you, Commissioner Sophia. Do you have any suggestions to add in number 3?
My suggestion is to put the word pending between criminal case and against.
Okay, thank you. And Commissioner Sophia, I don't know, you were gonna say something. Commissioner Casey also has a suggestion in the chat.
I did want to be specific that they could, after the criminal, let's say something, if I think Casey had some wording for that. I just can't see it on my screen. You know, at the conclusion of the cases, either party may request mediation. Something to that effect. Thank you.
And I just want to let you know we have less than 1 minute to resolve this issue. Thank you, Co-Chair Christian, to send it. Okay, I will pass it to Commissioner Dan.
My hand was still up from what I suggested, putting the word pending in, which I'm hoping would resolve the issue. Because the thing is, if we leave a thing that says that at the conclusion of the case, either party may request mediation. If the officer gets fired, I don't think that the board has any ability to ask the officer to come in for mediation anymore. And so I think we should say, leave it at, if there's a criminal case pending, and then the rest of it is implied in there. That it could be opened up after the resolution of a lawsuit, or if the officer doesn't get criminally convicted.
Okay, thank you. I'm fine with that.
Okay. And Commissioner Fate.
Sorry, I don't mean to belabor this. I think that I agree that it's implied. I think my only concern is that, and maybe this is a future us problem, like we could think about this to review later. It's not something we need to do now. But are there several or more, are there more than one place in which something is required, like this makes you ineligible, but then once it's resolved, you would be eligible, and we're not being explicit about that? So I think that's just one thing I'm flagging to look at in the future.
Okay, but you think we need to move on?
Right.
Can I ask the question? Are you okay? Okay. Is there a strong opposition to changing for what it was and what is now? Is there a general agreement to changing what it was and what is now?
I'm so sorry to interrupt, Victoria. There are two proposed variations of the same here. That,
Oh, I thought we agreed that only one variation was.
right, but there are two proposed and neither has been determined.
Commissioner Lewis said, after I made my proposal about the incident, wrote, "That works for me," in the chat. So I think we should just leave it at about the incident.
Okay, and then maybe one thing that may help is if commission members could maybe just propose everything verbally.
Yes.
I think that's probably in line with what the city attorneys would prefer anyway, the given previous guidance, but that might be helpful so that nothing gets missed. So I will remove this one and leave it, remove the stemming from the underlying incident and leave with about the incident unless Commissioner Casey has anything else on that, and then pass it back to Facilitator Victoria to ask the questions on it. Thank you. Thank you.
Okay, is there Commissioner Casey?
Just wanted to say no objection to that.
Okay, thank you. Is there a strong opposition to changing from what it was and what it is now? Is there a general agreement to changing for what it is and what it is now? Thank you. Can we move on? Okay.
So somehow it's become a lot smaller on my screen. I'll see what I can do. Okay. D, mediators shall be screened and trained properly about power dynamics, cultural awareness, racial bias, and other issues which may underlie the incident. E, for eligible cases, mediation is an alternative to full investigation. Sub 1, if either party rejects mediation, the case is sent to a full investigation. And sub 2, either party to the mediation or the mediator can determine that mediation is not successful and ask for a full investigation if mediation fails.
Thank you. Is there any discussion or questions? Can we move on? Okay. Next.
That would be me. I want to ask a quick question though, of staff, if wherever it says, Civil Service Board, if we can just automatically put Portland.
Sure.
Like we did on the other.
Yeah, you just flag that so it doesn't get missed anywhere.
Okay. All right, F2. Mediation is accessible and open to affected individuals and in some cases to people other than complainants. A, mediation includes accommodation for people with disabilities as well as interpreters as needed. B, to accommodate schedules, complainants can provide adequate notice of cancellation on as many as 2 separate occasions before mediation is abandoned. C, mediation is open to complainants as well as to family members of people subjected to alleged police misconduct with the complainant's permission, even if complainants do not themselves participate. And D, upon agreeing to the confidentiality of the mediation, one support person of each party's choosing may attend, but not engage in the mediation to provide moral support and consult during breaks.
Thank you. Is there any discussion or questions about F2? Can we move on? Thank you.
All right, so that's the last section of the actual document. We have a couple more things that we want to run by you, though. So, oh, is that a hand up, Commissioner Glenn?
Yes,
Commissioner Sophia?
yes. I would like to see the document one more time.
Okay.
I just wanted to make sure that mediation is, I thought I was reading that it's open to others. I know it's open to the members, I mean, the family members. But what about, I would say, audiences? I don't know how to explain that, like people who witnessed the incident. I was just wondering if that was somewhere included, or was there some discussion in the subcommittee about that?
Yeah, the word open, that should actually be available. And it's no, this is a closed process where it's basically, it's supposed to be a one-on-one between the officer and the community member. But
Yeah. I'm sorry, this is the idea that I had, or scenario that I had. Let's just say there's a community member or a neighbor who's witnessed an incident that maybe was very traumatizing to them. They don't make a complaint, but the individual that was involved does. I was just wondering if there was some kind of resolve for them, and I thought maybe mediation would do it. But if it's not something that's reasonable, it's just a thought. So I'm just leaving it. Thank you.
Thank you, Commissioner Sophia. You want to suggest that in case somebody cannot have a family member, they can bring somebody else, like a witness? Or you suggested that you also want, it has to be available for a witness besides?
Yes, I would, yeah, that makes sense, as well as a family member or witness. He says, Dan says, yes, next phase. Okay, what does that mean? Okay, I'm done for now.
Yes, it's because Commissioner Obi started the comment and Commissioner Dunn is answering, but do you have any suggestions here when they say as well as to family members? And
yes, I would say as well as family members and direct witnesses to misconduct incident, maybe.
thank you.
Thank you.
Co-chair Dunn?
I think we should probably just say or other community members in general, instead of saying witnesses, because I think it's too specific. I think that since we said with the complainant's permission, that means that, you know, basically whoever it is has to be somebody that the complainant gives a permission to. So I think or other community members or
Community members. Okay, are you okay with that, Commissioner? Sophia, that way they can bring another community member, not just a witness.
Yes.
Okay, then we can cross that. And I will pass it to co-chair Charlie.
I'm just curious too, if other community members or witnesses could file their own complaint. I mean, not in this section, but I'm just thinking,
yes, but that's contemplated very early on in this document. I know it's been a long time since we did that, but yes,
I know,
that is contemplated early on.
just a thought instead of getting all up in the family's business here. Anyway.
Thank you. Thank you. I'm going to, oh yes, Commissioner Charlie, oh yeah, you already passed Commissioner Charlie. I'm gonna ask the questions for F2. Is there a strong opposition to changing for what it was to what is suggested now? On C. Is there a general agreement to changing what it was, what is it suggested now? Thank you. We're gonna take a 5 minutes break. It's 8:40. We will come back at 8:45 and move on. Can we move on to the next when we come back?
Well, if you want to, I mean, all we have left is that the extra section and the timeline. Shouldn't take very long at all.
Okay.
Take like 5.
5 minutes. Okay, it's 8:41. We will start. Let's continue with the next.
Okay, so the original Part 2 document that was circulated by us co-chairs had a section that is similar to ones that you've seen in other documents. That is basically suggestions for City Council that we're making that are related to this topic, but the things that we can't change. So maybe staff, are you able to pull that up on the screen? Okay, so again, my view isn't working for this. All right, so there we go. Well, I had it for a second. So it's a section. It's labeled at the top.
You want sorry, do you want the new version or do you want the original Part 2? Apologies.
Oh, if you made a new version, then by all means, pull it up.
Yeah. It is here.
Oh, that's it? Okay.
Yeah.
Oh, so it no longer says, okay. So the overall thing says here, Police Accountability Commission's mandate from City Council does not require addressing these items. Nonetheless, these proposals support the Oversight Board ability to fulfill its mandate. Any problems with this? And so the broad outline of this full subsection here, and again, the full subcommittee discussed all these points, the individual points, but the broad message is the city should ensure that nothing in the upcoming collective bargaining agreements with the Portland Police Association or Portland Police Commanding Officers Association contradict or undermine city code related to the police accountability and oversight. I think we should get that word, that part was added today. I think the word upcoming should get rid of that. I think it should say nothing in collective bargaining agreements, because there's some that are in the current one. So the A discusses some alternative discipline items that are currently in New York. B talks about report writing not being eligible for stipulated, or being eligible for stipulated findings, but we're concerned that an officer might use that to cover up something. C asks whether or not officers have to be on duty when they're interviewed. D, if you can scroll down, talks about making sure that they're not required to interview officers in police facilities. And E talks about making sure the board can address deadly force incidents, which is right now prohibited by the current contract. Number 2 is about the city should also pursue amending certain items in the US DOJ agreement. And so if you want to scroll down to that, and I'll read these directly into the record. The city should pursue amending the US DOJ versus City of Portland settlement agreement to allow agreements in this document to be implemented successfully. A, paragraph 140 should include methods to communicate to the complainant other than mail, email, text, and fax. And then B, the timeline to complete an investigation should be extended from 180 days to 183 days, since that's actually how long half a year lasts. IPR's investigative timeline runs to 182 days. The PAC proposed timeline is 179 days, but the 2 months we have proposed to hold preliminary hearing and findings hearing should be 63 days rather than 60. And that is new. That the subcommittee didn't see that. If maybe we can bring up that spreadsheet that I created around this. I'm sorry. I'm just trying to get this done in a timely manner so we can get to the discussing the full document. Staff, can you pull up that spreadsheet and just the left half of it? We don't need for those who read this already, there's a part on the right side that just shows the original numbers that I sent to you all, and then I got clarification from IPR. So in the existing timeline, I feel like I'm in one of those movies with alternate timelines. In the existing timeline, intake takes 14 days. The case gets assigned to investigators over the course of 7 days. There's an investigation that takes 70 days. Then, and here's where things we're proposing to change stuff. The review and approval of the investigations would take 21 days in the current system. The supervisor of the officer makes findings, which doesn't happen in our system, right? The supervisor is not involved anymore. Independent police review, internal affairs, and the assistant chief review the findings to see if they agree or disagree with them. That's not going to happen anymore. Then they get 28 days for the police review board to be held. Then there's a disposition letter that gets written, but that can be all part of what is called the case closing paperwork, which we put in for 7 days, which mirrors what they do for case closing currently. All right, so if you look at the projected timeline, we're adding a week to the intake investigation to give the initial investigation a little extra time. Turning it over to investigators at the same time, 1 week. Investigation itself, same time, 70 days. Take 1 week less time to prepare the case for findings, and send it to the board, and that says 60 days. And the reason I said 63, we ran into this with the Citizen Review Committee, that if you have monthly meetings, because the quirks of the calendar, they often come 63 days apart instead of 60 days, which you'd imagine. So anyway, and then the case closing paperwork, another 7 days. And it's 179, but it'll be 182 if we extend that 60 to 63. So going back to that other document, we're suggesting that instead of saying 180 days, it should say 182 or 183, which is half a year. And that's pretty much what IPR takes now. It's basically to ensure that the board can meet monthly without having to adjust it by a day or two on one side or another just to meet these deadlines.
Thank you.
Thank
you, Co-Chair Dan. And what we're doing is that discussing or asking questions about these areas, correct? Are there any questions and suggestions or about these two? Number 1, number 2? Yes, Commissioner Fate.
I'm sorry, I want to make sure that I'm tracking, and Dan, that was the most in-depth Dan explanation I've ever seen. So I got to make sure that my brain was following what we're approving. So red text, we don't need to reapprove. Green text, we do need to approve. And Dan, you were providing us the background for section 2.
And
yes.
all of this text is stuff that needs to be approved because the commission hasn't seen it yet. So I'm asking for you to approve all of it if you can.
And thank you, Co-Chair Dan and Commissioner Fate, and the staff also clarify your question as well.
Yeah, so this might be helpful. All of this is essentially an additional section that is not a G. We have A, B, C, D, E, F. but it's not G. It's kind of like the at the end of the subject matter experts, there were proposals for federal state consideration. At the end of the access to information document, there were some things that were not required of the commission, but fit into the optional duties of the commission, things that are necessary to ensure the function of the oversight board success. And so to clarify the red and green, so maybe ignore the color for a moment. Everything from the A on down was in the document that was referred from the subcommittee. The one is sort of a synthesis statement that kind of explains why what links all these together. This is the exact text from those other two documents mentioned that is sort of the header that the commission used. So it's language you've approved twice already. And that's the top part of it. The little changes here that are in green were, some of these were framed as questions and just converted to statements to be worded the same way. And so that's what that's about. And then on the DOJ side, there was one item here, which was just reworded from a sentence fragment to a full sentence and broken out here instead of just saying agreement issues. And that's what came from the subcommittee. And then as co-chair Dan mentioned, the part B is new text, which the spreadsheet information might help support. And if I can just add one additional thing from a scheduling perspective, 2 months, 63 days is the exact optimal when you want 2 months. That is the time if you're trying to have consistent days of the week from a volunteer group that might want to ideally meet on the same day of the week regularly.
Thank you, staff. Is there additional questions, comments about these two numbers? Then can we move on? Oh, staff.
Just one, so sorry, one question. The phrase findings hearing, is that refer to what's called a full hearing up above?
Well, again, the screen is very small for me right now, but yes, and full, it should say full hearing. Thank you.
Thanks.
Thank you. Can we move on? Okay, thank you. We can move on to the next section. Okay.
The next thing that you're going to guide us through.
Yes. The commission has completed discussion on the document, and next on the agenda is discussing whether the commission should approve the draft areas of agreement with all the changes we have made today incorporated into the text. There is a potential agreements document that was circulated that gives some context as this decision. Before seeing if there is consensus around approving this document, we're going to hear from the public. After that, we will review the PAC values and goals. Finally, we'll ask if members want to make any final tweaks and then ask if they are ready to make a decision. We ask members to the public to keep their comments to 2 minutes in length and keep their comments focused on the draft document. Members of the public, we invite you to raise your hand in Zoom when you like to be called on. And I have one, and I don't know if I pronounce your name correctly. Thank you for being here. And correct me if I'm incorrect. Miss, is Moy Lavine?
Yes, that's correct.
Thank you.
Thank you. In my experience and that of my communities, the police are the single biggest threat to public safety in this city. The institution of policing in Portland, as everywhere in the US, was founded with explicitly white supremacist motivations. In fact, Portland was once the third largest center of KKK activity in the country, largely driven by the fact that more than half of PPB officers were Klan members. While many speak of PPB in Portland very differently today as some kind of anti-racist progressive haven, I see it much more like the KKK than any picture of anti-racism, love, or progress I know of. I've experienced the greatest community in Portland with JFPK, Justice for Patrick Kimmons. With them, I've collected school supplies for Portland youth, celebrated Halloween, danced, sang, supported Black businesses, entrepreneurs, artists, elders, and community members, and marched in the streets demanding justice. And as amazing as all of this is, I wish Patrick was still alive and that JFPK didn't have to exist. But for that to happen, we would need police accountability, because Patrick's murder by Gary Britt and Jeffrey Livingston, who shot him 9 times in the back on September 30th, 2018, was sadly predictable. Britt had already shot a Portlander before, and despite this, PPA and PPB refused to consider any serious accountability as they have for officers involved in multiple shootings generally. Without this, JFPK and others have had to continue protesting and demanding justice. Mayor Wheeler and PPB threatened such activists. Emboldened by this, a white supremacist murdered a JFPK activist, T-Rex, almost exactly a year ago. The police responded by coming to a corner on which we were gathering in solidarity and mourning less than 48 hours after this horrific murder, and they taunted us. So to end, we need accountability individually and collectively, and this needs to be thought about in terms of reparation, healing, and transformation. We need a revolution in policing and public safety. We need an end to qualified immunity. We need to demilitarize the police. We need continuous race equity and inclusion training for every officer. We need a drastic slashing of PPB's $250 million a year budget in favor of community, housing, education, environmental, and mental health investment. Because for 99% of the events police are sent to, an armed person trained to treat those they deal with as enemy combatants is literally the very last thing needed. Thank you.
Thank you very much, Mr. Levine, and we really appreciate you being here, and we really value and appreciate your words. Thank you. Thank you. Now, we will now briefly look at the PAC values and goals as a reference for this document. On March 24, the PAC adopted values and goals, and as a part of the decision, the PAC agreed to use the PAC values and goals as a reference point for future PAC decisions to ensure that all future decisions align with the values and goals. I will pass it to the staff to go through these documents. Thank you.
Yeah, so I'm going to do a little bit slower today, just because this is one of the places where the success criteria that you developed may be the most relevant. Maybe doesn't cover everything. That was also structural oversight and all that. But as you know, the PAC values and goals include equity, inclusion, anti-racism, harm reduction, transparency and trustworthiness, community-centered, and effectiveness. Normally we've actually just used this as a header, but there are actually parts of this intro that relate directly to this document. So I'll just scroll through it slowly. And please feel free to say if you'd like it to be scrolled back up at any point. And as you're reading, just a quick reminder that when this was approved by the commission on March 24th, there was a commitment that before every substantive decision, you would look back on this and ensure that the documents that you're creating, the structure that you're creating aligns with the goals that you set in this document. Go on to the first two goals here. We can scroll down to the third and fourth. Or as much of the third and fourth as can fit on the screen. Scroll down to the fifth and sixth. At least as much as, oh, it'll all fit, okay. Is there anyone who'd like me to scroll to any particular part? Co-Chair Charlie?
Yeah, not any particular part, but you know, it's the whole document. I know these are high-reaching goals and values, but I think this very system we're working in has prevented us from truly meeting these goals and values as hard as we try. So I just really needed to say that we have so much more work to do and to be more radical going forward. Thank you.
Thank you, Co-Chair Charlie.
Pass it back to you, Victoria.
Thank you, and thank you, Co-Chair Jay, for your comment as well in the chat. Will any of the members of the commission like to revisit any portion of the draft areas of agreement? Is there a strong opposition to approving the draft areas of agreement with all the changes we have made today incorporated into the text as the Police Accountability Commission areas of agreement and office accountability? Is there a general agreement around approving this document? Congratulations and
Woohoo!
work. Everybody has put, but especially Co-Chair Charlie and congratulations.
Thank you all.
Thank you for all your hard work. Now we need to go to definitions. We're gonna discuss the draft definitions. We ask you to follow normal discussion rules. Please be brief each time you speak. Please be facilitator. And finally, please be forward-looking in your comments. And staff?
If I can suggest skipping ahead, I think might make sense to get into the public comment and next steps today, if that's okay with the full commission co-chairs.
Instead of doing definitions?
Yeah.
Okay, it's up to the
I
co-chair.
support that.
Yeah, that is fine.
Okay. Then we go to next steps. Oh, general public comment. We will again invite general public comment to make to do any comment about this document, about what was discussed today, or about anything they want to share on to the police accountability commissioners. We invite you to make any comment to any of the attendants that are here. Please, if you wanna comment, raise your hand. Okay, I don't think anybody has raised their hand yet. No, okay, then we will pass to next steps. And I will pass it to the co-chairs for members' curiosities.
Thanks, Victoria. So as previously mentioned in previous meetings, member curiosities is a time where commission members can bring up any items to discuss, any follow-ups, or share any articles or readings that they would like.
Yes, co-chair Christian.
All right, thanks. I just two things. Wanted to say thank you to everyone. This is a really big lift that we did, as people like to say the word lift in that context. Really happy. Feel like everyone pulled together. Thank you so much. And I also wanted to reiterate what Co-Chair Michelle Wesley said, Commissioner Co-Chair Michelle Wesley said about us being limited by the system. I feel like I struggle with that a lot. And I feel like it's worth stating over and over and over again. And I feel like I don't state it enough. So I want to try, just like, I support that. I agree with that. And I feel like a lot of us on this commission are cognizant of that too. But we should say it out loud more often because it's frustrating. Yeah, thank you.
Thank you, Co-Chair Christian. I will pass it to Commissioner Casey.
Thank you very much. I know we're over time, so I'll try to be quick. First of all, I just wanted to mention to everybody that the reason I've been off camera is I had a spinal injury a couple weeks back. I'm hoping that I'm going to be able to get treated for that soon. And in the meantime, I apologize for not being able to interact more. I know it makes a big difference to these meetings to have everybody on camera. So I'm hoping I'll be able to have my face on the screen soon again. The other thing that I've been wanting to mention for a couple sessions is that I feel like it's important, it's certainly important to me to address the recent outcome with the investigation into the false information that was leaked on Commissioner Hardesty. And the fact that the man responsible for that information, Brian Hunziker, was reinstated with the Portland Police after being fired. I feel like when I heard that news, I believe it was last week or the week before, there was a sense of hopelessness that I feel like has been reflected in some of the people that we've had make comments in some of our meetings. Feeling like someone who acted so egregiously and harmed our community so deeply can basically have no consequences and can in fact continue to be embraced by the Portland Police Association as someone who made a one-time mistake and should still be out in our community carrying a gun and holding authority over our community members. But after working through those feelings, it just left me with such a sense of how important what we're doing is here, and how we're really never going to be able to have trust between our police bureau that's supposed to serve our community and the community itself, as long as there is no meaningful accountability for members of the Portland Police Bureau. So I just thought, considering the work we are doing, I couldn't let that event sort of go by without mentioning it in this context. I think I feel very similarly to the several commissioners mentioned today how difficult this work is given sort of the structural things going against us. But we gotta do this. We gotta fix this. We can't go on like this with a department that feels like it can act with impunity, and the community just sort of has to accept it. So that's what I have to say.
Thank you, Commissioner Casey. Commissioner Debbie?
So I just wanted to bring up the issue of our timeline for the full commission and just ask that whenever staff has any information to pass on to us as far as where that's going with the negotiations with city council, that'd be great. And I think it would also help those of us who'd like to write to city council members as individual commissioners, give us a better idea of an ideal timing. Thank you very much.
Thank you, Commissioner Debbie. Before I pass it to Commissioner Sophia and Commissioner Fay, I just want to remind everyone that we need also to discuss the phases of work transition task, and it will take between 5 and 10 minutes after this. Thank you, Commissioner Fay. Go ahead.
Just to follow up to Commissioner Debbie, I have drafted an email that I personally am going to send to City Council and their staff. And sometimes I like it when I can just copy and paste someone else's email. So if you would like, I'm going to send you all the emails, whom I'm sending it to, and my draft. And if you would, of your own accord, like to copy and paste what I wrote, you are more than welcome to. Thanks.
Thank you, Commissioner Fay. And everybody, a lot of people say yes and agree to that. Thank you. Staff, Co-Chair Dan, before I pass it to staff.
I'm just Commissioner Dan now. My subcommittee's over. Somebody had mentioned that there was going to be an interview on Channel 2. I watched the news on that channel, which I don't often do, and I didn't see it. I don't know if that was just cut for time, but I never saw it. I'd be interested to know if that ever came up. And then we have an event Thursday, and it's a little confusing to me if that's one of the things where we're supposed to be responding to our outreach coordinator to let them know if we're planning to go. Is that what the case is for that? Thank you.
Thank you. And I will pass it to Austin.
Hello, my name's Austin. I use she, her pronouns. Dan, great questions. Thank you. Let's see here. Yes, I also was expecting to hear the interview for KATU that evening at 11 p.m. It was not on there. They have not sent me the link yet. I have not heard back from them. So I don't know what happened there. I assume that their evening got full and that was pushed to another date. So I have not seen that yet. When I do have it, I will email y'all the link. And yes, there is going to be a private listening session this Thursday, and you can check your emails for more details on that. It will be virtual.
Thank you, staff. And I will pass it to other member of the staff.
Yeah, so just to speak to the question from Commissioner Debbie, nothing definitive, but yes, if anything detailed comes up, that it's definitely going to be something we pass on from council regarding the timeline request. The other thing that may be notable, and this is both a response and a segue, is that the commission published its Q4 quarterly report today. So the next step in that is that there would be a presentation of that to City Council. And as you will note, when you look in it, that very prominently within that is the December 8th, which is part of that quarter, request by the commission to the City Council for additional time. So I would imagine that once a date is scheduled for the quarterly report presentation, that might be influential on the commission members or the commission as a whole's timing on this. So that as soon as that's confirmed, we'll add it. And I'll just also reiterate what Victoria mentioned, that there's 5 or 10 minutes on phase of work transition task coming up today. So just wanted to flag that. Thank you.
Thank you, staff. I will pass it to Commissioner Sophia, and then we will go to the phases of work transition task. Commissioner Sophia? I don't know, you're talking or yeah, go ahead. We cannot hear you. You're in mute. Now you can talk. See, we can see.
Am I in mute still?
No, we can hear you now.
Anyway, sorry, I don't know. I guess my touchpad wasn't working, but I just wanted to note, and I can't remember exactly what Commissioner Casey said, but the article that we were talking about, it's all about arbitration. That's why I had brought arbitration up earlier, because that is a very, very strong point and police accountability. And if anybody has any comments or ideas for what's the word, adding or amending the structural oversight, please send those in. I mean, it's extremely important. So thank you all very much for listening. Thanks.
Thank you, Commissioner Sophia. Now we'll pass it to staff for phases of work transition task.
Yes, thank you. So just to first, congratulations. This is the last meeting of this phase of work because you've completed all 3 documents. And thank you in particular to the members of the subcommittee on officer accountability today for the work in creating that document and helping get it through, in particular co-chairs Charlie and Dan. So as we move ahead, one of the things that the commission has tried to do is to have subcommittees figured out and co-chairs figured out for both the full commission and those subcommittees as early as possible to help prep and get ready for the next phase, as opposed to trying to do that early in the next phase. So to that end, staff sent out a couple emails asking for folks to volunteer for subcommittee membership, and then another one asking for folks to volunteer for subcommittee or full commission co-chairs. This worked out that there are 9 co-chair positions and 9 members of the commission have volunteered to serve in those 9 positions. So there's a very, possibly easy prospect, depending on how you all feel about it. But first, it should be mentioned that there are, the bylaws do mandate that the full commission choose to approve their co-chairs. And so I just wanted to kind of walk through this and explain how it works really quick. And then if there is a consensus to approve each of these co-chair pairings or trios in turn. So at present, there are 3 volunteers for the 3 candidates for the full commission co-chair. Those are Catherine, KC, and Charlie. There are 2 volunteers for the subcommittee on reporting and transparency. Those are Debbie and Connie. There are 2 candidates for the subcommittee on board membership. Those are Obi and Tirsa. And there are 2 candidates for the subcommittee on oversight agency, who are Dan and Jay. So that is the list right now. Just really quickly, we'll separate these out, but I just wanted to speak briefly to the bylaws. Just going to quickly show this because it relates to the full commission co-chairs, and then ask about this. So sorry, that's strange. Okay, apologies, my internet's a little slow today, so if you saw how it didn't load this page at all. It's just a blank page for a second there. Okay. All right, so yeah, the co-chairs of the commission are responsible for conducting the meetings of the body, acting as chair in the others' stead, remain active in voting members. The next one's really about facilitation. And then the last 4 here: full and safe participation, liaising between members of the commission and the city, working with staff, facilitators, commission members to develop meeting agendas, establish subcommittees, ensure quarterly reports, and ensure an efficient advisory process. And again, can share and allocate the tasks in whatever way that they choose amongst themselves. Are there any questions on the role of the co-chair before we ask for folks to potentially approve them? Okay, so again, there are 3 positions for co-chair. There are 3 members who volunteered. One is Commissioner KC, one is Commissioner Catherine, one is Commissioner Charlie. Is there a proposal at this time regarding approving co-chairs?
Yes, Commissioner Fate.
I propose that we approve these co-chairs.
Great. Is there any strong Commissioner Connie? Okay. Is there strong opposition to approving Commissioners Casey, Catherine, and Charlie as co-chairs of the commission for the structure and details phase? Seeing none, is there general agreement to approving those three members as co-chairs? Congratulations to all three of you, and thank you for taking on the work and the role. Next, we'll talk about the subcommittee co-chairs. So this position is defined primarily through the internal processes, and you'll see this is just a shorter version of the other list. And again, apologies for the delay here in the loading. Yeah, so again, it talks about 2 co-chairs per subcommittee, conducting the meetings, acting in each other's stead, remaining active and voting members, safe and full participation, a shorter list of duties under F here, and then can share or allocate the tasks amongst themselves. So just going in the order that they're anticipated to begin meeting, in the interest of time here, we'll start with reporting and transparency. There are 2 commissioners who expressed interest in being co-chair that, Commissioners Debbie and Connie. Are there any proposals related to the approval of co-chairs for this subcommittee? Co-chair Christian.
I propose that we approve these co-chairs.
Great. So is there any strong opposition to approving Commissioners Debbie and Connie as co-chairs of the subcommittee on reporting and transparency? Seeing none, is there general agreement to approving them? Congratulations, co-chairs, Connie and Debbie, for the subcommittee on reporting and transparency. Moving to staff, or should I say, sorry, oversight agency, and learning Christian's different hand movements each time. Yeah, there are 2 commissioners who expressed interest in being co-chairs of this subcommittee, Commissioners Dan and Jay. Are there any proposals on this particular approval process? Commissioner and co-chair-elect Debbie?
I propose that we select these 2 to be the co-chairs of the agency subcommittee.
Yeah, so there's a proposal to approve Commissioners Dan and Jay as co-chairs of the subcommittee on oversight agency. Is there any strong opposition to this? Seeing none, is there general agreement? Congratulations to Dan and to Ajay. And finally, the subcommittee on board membership, there are 2 members who express interest here, Commissioners Obi and Tirsa. Commissioner Obi had to step out of the meeting, but re-expressed it on the way out. So just wanted to clarify that. If there were any questions there, are there any proposals related to this approval process? And again, this is for the board membership subcommittee. Someone's got to make the proposal. So co-chair Charlie.
I propose approval for Tirsa and Obi for this subcommittee.
Thank you. There is a proposal to approve Commissioners Obi and Tirsa for the subcommittee on board membership. Is there any strong opposition to this proposal? Seeing none, is there general agreement to this proposal? And then once again, we have consensus. Congratulations to co-chairs-elect Obi and Tirsa. And I just want to congratulate all of you because I think this is the first time we've done this by the end of the proceeding phase. So, and also 9 people, which is amazing. Yeah, I think everybody now will have been a co-chair at some point in this, except our newest member who just joined a couple weeks ago. So congratulations to you all and thank you all. I'll pass it back to Victoria.
Thank you, staff, and congratulations to everyone that has committed to serve and to be a part of this next phase. I'm looking forward to work with all of you. This is the garden plot recap, and it's a time for facilitators, co-chairs, and the staff to summarize any items already brought up today which didn't fit into today's agenda. We'll recap those items here and use them in developing future agendas. We won't be using this time items not previously mentioned or to discuss any items, but we will use this list to develop future agendas so these items can be addressed. I will pass it to the co-chairs first. Is there anything on the garden plot for the co-chairs? No? Okay.
I did
Yes,
have,
okay.
yeah, sorry. There were a few items that were flagged for revisit, like I should have written down more specific examples. I just wrote down the like C sub 2, like whatever was in that section. So I have a list, which is A, E, 2, A, B, A sub 1, C sub 2. Not like to revisit in the document, but as like the topic in there was something that we wanted to visit for later. It's the things that to suggest to council, and maybe change state law, stuff like that. I'm sorry, they don't have specific examples. Those two, and then F, B sub 3 was another one too. So the topics in there were things that we were kind of like wondering about for future. Thank you.
Thank you, Co-Chair Christian. That's very helpful. Thank you very much. Commissioner Dan?
Yeah, well, I'm still wearing a little bit of my co-chair hat. We had another subsection at the end of the original document with items that we came across while we were working on this phase, but that will help us in the next phase. So those are like notes to our future selves, and I just want to make sure that those don't get lost when we transition to the new phase.
Thank you. Thank you, Commissioner Dan. Now I will ask staff if they have anything to add on the garden plot.
Just going to screen share that stuff that Commissioner Dan just referred to. And then the specific item is the section that was tabled out of this with relation to arbitration and selection for that. Everything else is also on the list. I just wanted to add that one specifically.
Thank you. And okay, I don't have anything to add. Then we can go to slide 27. And they say, as a reminder, you can now submit advanced public comment to the Police Accountability Commission via web form, voicemail, or postal mail. Thank you to all the members who attended today's meeting and for your contributions today. Thank you also to the interpreters. Finally, thank you to the members of the community for attending and contributing your thoughts and questions. If you're not ready to sign up for email updates, please sign up to receive updates from the PAC. It's now 9:31 and this meeting is adjourned.